For all of you joining us live today and the number of you joining us on the replay, thank you for sharing your time with us and joining us for the My Wealth video series. My name is Jeff Hunter and I'm a portfolio manager with the Townshend, Somani and Hunter Group at Canaccord Genuity. Also on the line is our lead investment advisor, Somani. For more information about our team and the My Wealth portfolios and process, please check out mywealthmanager.ca. Today's call is with Mackenzie Investments, Tim Brisibe and Mark Russell on estate planning. All participants have been muted, but in the chat below, feel free to direct any questions to us and we'll do our best to address them in the time permitted. Today's call is being recorded, so make sure to check your emails in the coming days for the replay information or follow our team's Facebook page at facebook.com/mywealthmanager.ca. With that, I'll pass it off to Mark Russell.
Great, thanks, Jeff. And Raheem, very much appreciate everybody and the whole team at Canaccord for having us on. Very much appreciate it. It's my pleasure to have a conversation on estate planning and also interact with Tim Brisibes. Tim is a director of our tax and estate team and extremely knowledgeable on estate planning topics, some of which we're going to cover off on a fairly broad sort of top level basis, if you will, but we'll get into the weeds a little bit on some of the points. I know Tim gets a little bit passionate about some of the estate planning side of things. It's tough to maybe think about being passionate about estate planning, but Tim is one individual who is passionate about estate planning. So Tim, with that, you know, you've been doing this a number of years in the industry and interacting with individuals and advisors alike on the topic of estate planning. Maybe sort of describe some of the conversations that you generally have regarding estate planning. Maybe we'll get the juices flowing for people thinking, you know, estate planning is a very broad topic. You know, what exactly are those conversations like? Maybe describe to the audience what some of those conversations are generally about.
Yeah. And I want to thank everyone for joining us today, and certainly yourself, Mark, for taking this on as well and enabling us to provide important content to clients. Broadly speaking, and I can go on for a couple hours just on your first question.
There's the passion I was talking about.
But broadly speaking, I'll just touch on two very quickly. I remember a conversation that I had with a client. I believe Kathleen was there as well. And this is just not too far from, she may have even forgotten, but it's not too far from where I live. I live in Seaton, in Southeast Calgary. And there's a restaurant that's not too far from me. It's called Starbelly. And we had a webinar there, a couple years ago, and there was a client that attended with his common law partner, which is fine, obviously, but then the twist is that he was still married, and he had a spouse, and they were going through a divorce, you know, and the divorce was not finalized, but it was in a common law relationship, and he had 3 kids from his spouse. And so there is a common law partner, there's also a legally married spouse, and there are 3 kids involved. And I think good for him, he was attending such an estate planning seminar. But what he didn't consider was, and this guy didn't have a will, you see, and so the way it would generally work, the way the wills and Succession Act in Alberta provides, if you have a common law partner, which is called the adult interdependent partner and a spouse, and you don't have a will, your assets are generally split between the two. You see, and so it seems to me that if he's going through a divorce, he may not wish for his spouse to receive anything from his estate.
Right, that could make for some awkward conversations, maybe.
That's right. You know, so these are some of the conversations that one has had. Another one, very quickly, in Northern BC, I was doing a seminar, and I flew into Terrace, BC, and I was in a cab, and the cab driver asked me what my business was in the city, and I told him, and he said he didn't have a will, and he didn't care. He had real estate, he had rental property, he had investments, and he had 3 kids, and he was married. He said, when I die, they can fight over it, and that's their problem, not mine, I'm dead. I've had very interesting conversations with people, but the point being, it makes a ton of sense to plan. Otherwise, we're throwing our families to the wolves, and only disharmony and heartache and such things can come out of it.
Right. Fair enough. No, and those are a couple of good examples of, reasons why, having an estate planning conversation first and foremost, and then organizing yourself to put things in writing and then get into the legal documents that coincide with estate planning makes so much sense. There's a lot of moving parts, and family dynamics come into play on almost every level. And with that, family conflict, I mean, it's described as the single largest issue that arises during estate planning conversations and challenges.
Yep.
Are there any ways to avoid it other than not having a family? How can we avoid family conflict?
I think a fundamental way, and this is not a strategy, it's just what you do, is to have a conversation.
Right.
It's just to have a conversation, and verbal conversation, but I think what underscores that will be communication. And you can communicate verbally, and certainly you want to reduce your communication in writing, which can take many forms: the enduring power of attorney, the personal directive, the will. And sometimes also, it's good if you name an executor. The executor needs to know where the will is. Where is the will located? So just broadly speaking, communication, conversation. But I think in the family unit, it makes a ton of sense. If we want to minimize disharmony and conflict, which, like you rightly pointed out, this is the leading threat to estate planning, is family conflict. And very quickly, an example would be, and this is a very simple example, it can go just downhill from here, would be you have 2 children, you've got, you name one as the executor of your estate, and you didn't name the other one for good reason, right? Because you've got Jeff that works in financial services, knows his way around this stuff, and that's why you named him, but not the other one. But if you didn't communicate to your other child that this is the reason you named the one, once you pass away, and I've seen this, there is button heads, and there is one you're favored by dad and mom over myself, without the benefit of explaining ahead of time why you made such a decision. So conversations would certainly limit this threat that leads that with respect to family estate planning. Conversation limits the threat exponentially.
Right. It makes sense. I mean, I think having that open, free conversation and making sure everybody's on the same page helps avoid, some of the potential unintended consequences that may come through when somebody passes on and the assets and the estate is dealt with, which makes sense. So, knowing that everybody is on the same page and having that open, free conversation makes a ton of sense. And I think somewhat surprising that not everybody does it, or that it's infrequently done. So there's lots of surprises. So I think in communication is big. And what about, on that communication, on that same line, communication, not just with the family, but also with the professional advisors in your life, be it financial, legal, accounting, what have you. What sort of communication strategies would you recommend for that?
That's key. That's key. And again, we've seen where, I'll just give you a quick example where you're going for your annual review with your financial investment advisor, and they're going through your affairs and your investments. And because these days, the advisors that are good at what they do, they go beyond, or in addition to investment advice, they want to embrace you as a family unit. So this is called family office planning or mindset. But then some clients would, say, or keep this to themselves. I've got an asset that I jointly hold with another person. And upon my death, the asset just goes by operation of law to that person, the survivor. So there's no point bringing up this with my investment or financial advisor. And there can be challenges. So that's just one point. For example, you know how joint tenancy works, where there can be downsides to joint tenancy, exposure to creditor. If you add a child as joint tenant on your investment account or real estate or things like that. So I think in as much as it is significant to have conversations with family, it is equally as important to have these types of conversation with your investment advisor, because they know what you don't know and they have access to professionals that they can deploy to help the client with what it is that they're planning with respect to their estate. So it is very key.
Right. And you know, I would concur with you in terms of, you know, the advisors that are in individuals' lives. You know, they can give a perspective that's a little bit different. They can have an unbiased perspective. They can give that holistic view. So your financial advisor is absolutely key in helping to orchestrate. So making sure that you communicate,
correct,
you know, what your estate planning objectives and goals are and where you are in that. I think that's an important conversation to make sure that we're having with the financial advisors, such as the gentlemen that are hosting this this afternoon. So that's.
And I'll just touch on very quickly, Mark, before you move on.
Yeah.
We just recently, in fact, it was yesterday or last week, published an article on advisor.ca. Mm-hmm. And the topic of the article is non-resident executor. I just thought of that, so I thought I'd bring it up, where clients would name a child that lives in the United States, right, for example, and they live in Alberta, right? And what are the challenges potentially that would be the estate will be faced with? Right. You're talking about taking out a bond, taking out security, logistical, issues, but also if an executor resides in another country, the estate may be deemed to be an out of country estate, and the tax regime of that country may be brought to bear on the estate. And so you've got competing tax regime, Canada and the United States, or the jurisdiction in which the child resides in. So the investment advisor, again, is central in guiding their client as to how to make the right decisions with their estate affairs.
Right. That sounds messy and complicated. And, you know, and just as you were saying that, you know, with having some children of my own, thinking of them named as executors on my own will, and what happens if they move, 10 years down the road and they depart and leave in the US, and all of a sudden I've opened that up. And if I haven't had that conversation or continued conversation with my advisors, unintentionally, I might expose my estate to some things. So that's a great point to bring up.
That's right.
So with that, you're talking about earlier in the conversations that you had, and you mentioned, the cab driver in Terrace, BC. Don't have a will, don't want a will, don't need a will. Who cares? Let the kids scrap it out, and the strongest will survive, and whoever comes out of the pile gets all the assets.
That's it.
Type of idea. Talk about wills. What are the stats on wills today, like, in terms of how many people have them or don't have them?
Yeah. In Canada, there was a fairly recent poll that was done. Half the country adults, and half the country don't have wills, right? And so half the country means half the lawyers in the country,
right?
And half the lawyers in the country means half the estate planning lawyers in the country. And so one of the things I would say is that if you're going to a lawyer to have your will drafted, I would ask them if they have a will. If a lawyer doesn't have a will, I probably don't want to use that person.
Right.
Right. That's something to keep in mind. But half the country, you know what I mean?
Yeah, absolutely.
That's right. I used to work at RBC Royal Trust administering estates, and I was told prior to my time, there was a senior trust officer that had worked at Royal Trust for 25 years, and he suddenly died of heart attack, unfortunately. And all he did for 25 years was administer estates and advise clients on estates and wills. He died, he didn't have a will.
Wow.
You see,
Wow.
so these things happen. And so half of the country don't have wills, and there are all kinds of reasons for not having wills or enduring power of attorney or personal directive. Some don't want to think about dying. You know, your mortality, you're faced with it. So let's not just have that conversation. Some think it's too expensive. Some say they don't have enough assets. Some, you know, I'm too young, and so on and so forth. But not having a will means that when you pass away, you die intestate.
Mm-hmm.
And that creates a ton of challenges and a ton of problems. So you may want to save money on the front end, saying that it's too expensive, but the cost financially and otherwise on the back end would just be so heavy and creates all kinds of problems for members of your family. So I'd see a lawyer, have them explain to me and walk me through wills, enduring power of attorney, and personal directive. Yeah.
Right. Yeah, it's that's interesting. That's you know, the comment on, you know, statistically speaking anyway, 50% of the country without a will, 50% of lawyers, ergo, wouldn't have a lawyer. It's that nutritionist that you have that always eats McDonald's. It's a bit it's a bit ironic, I suppose. So maybe walk us through a little bit, Tim, on, you know, what's going to happen for this, potentially for, I guess, for this cab driver, you know, the day that the individual passes away. What happens when you die without a will, when you die intestate? What's the process? What happens?
When one dies without a will, in fact, let me back up and give you an example. And this happened, unfortunately, as a Sun Life advisor in his early 30s. This happened about 8 years ago, and he suddenly collapsed at his desk, and he was rushed to the hospital. He didn't have a will, a personal directive, or an enduring power of attorney. But in this case, he had lost capacity. And what happens with the medical care that he ought to receive quickly and as soon as possible? Now, in that case, the doctors would provide the immediate and initial medical care. But what happens subsequently? Because he didn't have a personal directive, which gives directive basically as to how medical care would be administered to the person, in this case, to the Sun Life advisor, then a member of his family would have to go to court, get an order, and this takes time, and it's costly, and you involve lawyers potentially in this. That's never good, because you have someone lying in a sickbed needing care that no one at that point has the authority to provide direction on ongoing care. Experimental treatment would be an example, right? Who gives the go-ahead? So now, with respect to a will, you die as an intestate, and immediately the administrator, which is the technical term for an executor if you died without a will, needs to be appointed. Will it be one child over another? Will it be, if you have a spouse, then your spouse certainly will be named, but someone will be named. And again, you're talking lawyers, you're talking fees, you're talking time, and immediate care for the beneficiaries of the estate would be left for a number of weeks, maybe months, while you struggle and potentially even fight over who will be named as executor. What happens to guardians of, to minor children? Who are you naming? And so there are all kinds of things that may happen with respect to tax minimization. Have you planned? If you haven't, then the CRA now takes a bigger pile of your assets than you otherwise would want. We can go on and on with respect to an intestacy. So again, to guard against that, get a will. It's just the short answer. Yeah.
Yeah, I mean, it sounds, you know, from what you were talking about there, that, you know, if you die without a will, that at a bare minimum, it delays a lot of, you know, the process to have your estate wrapped up. Correct. And there could be significant challenges with that, especially once you start to introduce children or other assets or other things, it could be very complicated and messy. So you're right. Bottom line, let's just get a will and have our wishes down in paper and legal so that the process is executed as we would want. So thank you for that. And in that, also in that explanation, Tim, you touched on a couple of things, other documents I think that are imperative when it comes to estate planning, and that is personal directive and power of attorney. Can you just, personal directive, I think you were alluding to sort of healthcare decisions. So I think that's a document specific to healthcare, and power of attorney. Maybe touch on those and why we should have those.
Yeah, so it's a threefold document with respect to estate planning. Those are your basic tenets of estate planning, right? The will, the power of attorney, and the personal directive. Now, the reason I think I've mentioned enduring power of attorney a couple of times would be you do not want a regular or a basic power of attorney. If you have a place down south and you're a snowbird, or for whatever reason you're going out of town, and you want someone to engage another person on your behalf with respect to your property, then you can have a power of attorney that has a start date and an end date, right? Very restrictive, and you can have that. But now, what if you lose capacity? Then the person that you name on your basic power of attorney, they can no longer act. So again, we go back to lawyers and time and money. So you want an enduring power of attorney that will endure beyond your loss of capacity. And you name an attorney to make decisions for you with respect to your investments, real property, tangible things like that, right? They will deal with your investment advisor, restructure investments if that is what is necessary. And finally, I would also say this, maybe some in the audience, they are not in this age group, but it will get there, where when you turn 71, if you have an RSP, you have to convert the RSP contract into a RIF. And if you've lost capacity and you do not have an enduring power of attorney, because the beneficiary designation does not transfer from the RSP to the RIF, then by default, you don't have a beneficiary in your RIF. And this is where an enduring power of attorney would be helpful. Provinces are changing the law with respect to that, where it wasn't possible to now redesignate the exact same person in your RSP onto your RIF when you convert. But your attorney in Alberta, they're working towards that, where your attorney under an enduring power of attorney can redesignate the exact same person on your RSP onto your RIF. So some of the reasons why it makes sense to have an enduring power of attorney. I gave the example of the advisor with respect to the personal directive. That is one of the reasons why you need a personal directive, which is obviously different from the medical assistance in dying. That's a whole different conversation.
Right. Fair enough. So those are sort of the three core tenets: a will, personal directive for healthcare, and power of attorney for financial decisions. All three should be in place, almost irrespective of your age. And conversations that people should be having with other family members, be it young adults or parents, grandparents. We should be making sure that all those documents are in place. So thank you for touching on that. Question for you. When should these be updated? Like, we get this set, maybe we have an event in life, we have the birth of our first child, and we're like, oh my gosh, we gotta, let's get our will in place and what have you. And then, you wake up in a week and the child's graduating university and they don't need a guardian anymore. When should we be updating these documents?
I'd say default is life events.
Okay.
That'll be default. And you just touched on that, Mark. You give birth, you look at your will. The child is no longer a minor, they're an adult, then you look at your will. I'll use myself as an example. I've got a 20-year-old and my daughter is 17. And so my wife is the sole executor of my estate, of my will. And the reverse is true for her. The alternate executor of my will is my oldest, and he's an adult, he's 20. But now I didn't leave it there. I made him co with the trust company. Now I went further to provide for, as soon as my daughter turns 18, which is October of this year, then the trust company falls off and she becomes the co-executor with, alternate co-executor with her brother. And then we have things in place where they can have immediate access to advice and support if they were called upon to act as alternate co-executors. And so it's just time and life events would instruct how and when you certainly review your will. And the other one would be, just the general default would be every 3 to 5 years, just go in and take a look and just see if your will and the provisions of your will still reflect your current circumstance. So those two defaults, yeah, life events, marriage, divorce, death, illness, and certainly every 3 to 5 years would be a good time frame.
Right. Fair enough. No, that's good. It's just good to have in mind, right? Just as a reminder for folks, right? To kind of, you don't just sign up for it and forget about it. Things change, life changes. So we need to make sure those are sort of living documents, right? They're living, breathing documents that kind of evolve as we evolve. So to make sure that updated as well is important. One of the things, you hear about wills and when they're being processed and, the estate plans and the executors are involved is, one of the terms we hear about is probate fees and probate. What is probate and what are the costs associated with probate? And are there any ideas or ways that we can avoid it? Anything with a fee, we'd like to try and avoid if we can. So any ideas around probate fees and how I can not pay them?
Yeah, I'll go one step further. Anything around fees you want to avoid if you can. Anything around tax you want to avoid if you can. Not evade tax, but you want to avoid tax if you can. And so probate, there are fees associated with probate that you pay court fees, right? But generally speaking, across the country, they're called fees, but they're tax actually. So we call them probate tax, right? Now, we're fortunate in Alberta that we have a flat fee or a flat tax with respect to probate. It is irrespective of the value of one's estate. Probate tax in Alberta is $525. Okay. By comparison, in BC, the probate tax is 1.4% of the gross value of one's estate. In Ontario is 1.5%. In Nova Scotia is 1.6%. So it's flat over here in Alberta. Now, what is probate? Now, probate is just the confirmation by the court that the person that you named as executor and the will is actually your final will, because the executor derives the authority from the will, not from the court. But the court is saying, we've searched and we believe this is the last will of the deceased. And you do that for a number of reasons. Now, if you have real estate in the estate and you want to transfer or sell the real estate, land titles will not be registered in the name of the new owner without the grant of probate. Certain financial institutions will not release monies that are held by the deceased in those places without the grant of probate. Some institutions have thresholds. So if you've got $25,000 or less, if you come with a certified true copy of the will and the death certificate, you're written a check. But if it's 25 and above, then you need the grant of probate. Another reason you need probate is the protection of the executor. It's been known that another will would surface and you've been working all along with this will that you believe to be the last will. And if you administer the estate, you disburse all of the funds and a later will surfaces, the executor is in deep trouble. You've paid out $1 million, but you've operated under false assumptions or the false will. So now you have to go chase down the beneficiaries, but they're in Cabo, someplace. You can't retrieve the funds, right? But if the executor goes through the probate process, receives a grant of probate, and another will shows up, the executor is absolutely protected. And so these are some of the reasons why we encourage executors to go get the grant of probate. Now, you don't always need probate. Jointly held assets I referenced earlier. So if the property is jointly held, it bypasses probate. If you've got a beneficiary designation on an RSP, RIF, TFSA, it bypasses probate. And certainly say on an insurance policy, it bypasses probate if the estate has not been designated as beneficiaries on these plans that I just talked about. So these are some of the ways that probate and probate tax or fees can be avoided or bypassed. Yeah.
Right. Okay. So sounds like Alberta's got a fairly reasonable flat rate at $525.
That's right.
I suspect if you're a resident in BC, Ontario, or potentially down the road, there might be some strategies you want to implement. And I think if there's any account that has a beneficiary on it, we want to put a name on there. We want to make sure we name a beneficiary so that that does actually go directly to that
person
or entity. Yeah. And same with life insurance to circumvent that attracting any probate tax, especially in provinces like Ontario, BC, and Nova Scotia. Sounds like they've got some fairly hefty tax rates on probate bills. So especially with
certainly some folks have a secondary vacation property in BC.
Yeah.
And you got to think about that and take that into account because your property there would come under the probate regime in BC, and that property will be taxed at 1.4% probate tax.
Right. So potentially holding that in some sort of form of joint ownership, joint tenancy, as you referred to earlier, might be a thought, but that's a conversation that we have. And that's why we have those conversations
constantly
with our advisors and people that are involved in our life. So no, I appreciate that, Tim. And you touched on another term and word quite frequently in that explanation on probate, and that was executor. And you mentioned it earlier with your own will and naming your own as executor, and then your youngest, who's about to turn 18 this coming October, is going to be joint executor. What is the role of an executor? What is that all? What do they have to do? What are some of the duties at a high level? What are their responsibilities that they need to endure? I think a lot of people name their children, as you have, as an executor. And I think a lot of people sometimes find out they are an executor. Unfortunately, the day after mom and dad pass away, I find out I'm an executor. Now what? So what are some of those roles, and do they get compensated for some of that work?
Yeah, take the last first. They can get compensated. They should get compensated. It depends on the complexity and the breadth and scope of the estate, number of beneficiaries, holdings, things like that. But generally speaking, if you name your child or your kids, like I've done mine, both children would ultimately be co-executors. Then, if you take out a compensation for yourself, then you're just taking out money from your inheritance that will be taxed, because compensation is income and will be taxed. So you just leave that alone. But if one child were executor and another, and that child has, expended time and resources and energy into administering the estate, for sure, they may want to take out a fee that will be commensurate to what they've done with respect to administering the estate. Now, so talking about administering the estate, that's the role of the executor from start to finish. See the administration of the estate. So this person has died, mom has died, or dad has passed away. And you mentioned, I just discovered that I was named executor, and that can be shocking, right? What about if the executor you named has passed away didn't even know that they were named? And that portion of your will becomes an intestacy, So it is good in talking about conversation that when you name an executor, let them know, or better still, seek their consent before you name them as executor. That way they know and they're ready and able and willing to act, right? So once they're ready or they're willing to act, then you go into the technical details of what it means to administer an estate. And I tell you, even the simplest estates can get very complex very quickly, just based on the sheer number of entities that you're dealing with. Financial services, you're dealing with realtors, you're dealing with appraisers, you're dealing with the CRA, you're dealing with Service Canada, you're dealing with pensions and employers and last check and death benefits. And so it can be really daunting. Those are some of the basic roles of the executor. Change locks. If this person lived alone, you want to change the locks of the apartment or the condo or the house, because you don't know if the neighbor has a spare key to look after the plants when this person went on vacation for a couple of weeks. You want to immediately change that. You want to just stop subscription, because it piles up on the doorstep sometimes, and it shows that someone's no longer living at that place. So it's varied. This is why you need help. And certainly the financial advisor is the key person that can provide you with help. And finally, I'll say this: some financial institutions have what's called agent for executor. If you're executor and you don't have the time or the expertise to deal with an estate, you may engage an entity that would do it for a flat fee, but you remain the primary decision maker on that estate.
Okay, no, that's good. That's lots of pointers. I mean, the role of an executor is pretty deep and in depth potentially, right? Depending on the complexity of the estate, and having a bit of a checklist. And I know that we produce a checklist, yeah. And you know, Raheem and Jeff and David there certainly have access to executor checklists, which are just good handy pieces to have that you may want to have almost as, you know, wherever you're storing your will, you may want to include that checklist beside it so that when your executor does go through it, they can sort of start top from bottom. And, you know, you mentioned a couple of things there that stood out to me in terms of the subscriptions. And, you know, I just started thinking, you know, my Netflix subscription, my iTunes subscription, like all those things that just
online accounts, yeah,
keep rolling, right? So you know, having those turned off, I mean, they don't seem too much, but they add up, and it could go by for months, right?
Yeah.
And with, you know, the use of so much more electronics, passwords,
correct.
Having some sort of area where passwords are accessible for my bank account information or what have you, right? I think having passwords somewhere where your executor can access them once you pass away is an important thing.
That's right. Yeah.
Yeah, absolutely. And I guess with that, on, you know, the estate side with business owners or small business owners, is there anything different that those individuals should be thinking about when it comes to estate planning ideas? Yeah,
business owners, we have it's not a terribly good stat for business owners now. Across Canada, we talked about 50% not having wills or estate planning documents. Business owners, 75% don't, which is egregious because you spent your time, you spent your life building a business from ground up. And only 25% of business owners have a succession plan and estate plan in place, and certainly written. And so we encourage business owners to really think about this. Right. So you want succession planning, you know, how do you maximize the lifetime capital gains exemption, you know, which is upwards of $800,000. How do you plan for that? How do you plan to avoid double taxation? Because for business owners, this is potentially a place where you are exposed. On deemed disposition, on death in Canada, you're deemed to have disposed of your capital assets, of your assets, right? And there is a tax there, but there's also potential for another layer of tax for small business owners. But if you don't plan ahead of time, then you're exposing your hard work and the assets that you built over decades to double taxation, which makes CRA extremely happy, right? But you want to avoid doing that.
Yes.
And so we go back to the basics. You need a will. You need an enduring power of attorney. And for business owners particularly, do you name someone that is savvy about your business, but savvy about business in general, to be the attorney on your enduring power of attorney, do you want to consider 2 enduring powers of attorney, one for your private stuff, your personal stuff, and one for your business in the event that you lose capacity? Same for a will. It is possible to look into that, but certainly for your enduring power of attorney. Couple more things. I'll just say shareholder agreement, right? Shareholder agreement is key. What about when you pass away? I was speaking with a business owner, and Mark, this is a seminar that you and I did a number of years ago downtown Calgary when we could do such things, where there was a business owner there, small business owner, and he said he had a business doing very well. He had 2 sons, 2 children, and he had named both as shareholders in the business upon his death, 50-50. One was working in the business, the other one wasn't. And I said to him, what if the child that is not working in the business takes out a loan and uses his 50% shareholding as collateral for that loan? And what if he's unable to pay back that loan in a timely fashion? The bank now becomes a shareholder by default in the business. So for business owners, we can do a whole session, and we've done this over time to talk about estate and succession planning, just some of the things to think about.
Yeah, no, it's certainly a whole topic unto itself, definitely. But just as a broad view,
that's right.
If you're a business owner, or a business owner, and you're in this conversation, you just want to make mention or make sure that we have some documents. There are other considerations to make sure that are incorporated in your overall estate plan. If you are a business owner, there are other things to think about, and that goes back to our initial points and talking about communication. Involving our advisors in our lives and in that relationship, it's key to make sure that we're constantly communicating with them to keep them abreast of what's going on, because maybe you become a business owner down the road, maybe in 5 years time or 10 years time, and you've kind of forgotten about this phenomenal presentation that was just on estate planning. Maybe this topic is kind of, you've forgotten about it. But on that last part, so we touched on the 3 tenants, and we'll potentially open up for questions if there's any questions. I know folks can type in the Q&A icon that's at the bottom of the screen. But sort of one last question, and it's back to my favorite one, which is fees, and trying to minimize those. What are the costs of those 3 tenants? Like you talked about a will, a power of attorney, personal directive. Generally speaking, how much do they cost to get one up and going?
I'd say the range would be approximately, for those 3 documents, a good lawyer would do those for $1,200 for the 3 documents, right? So if you're a couple, you're looking at, that's the range.
Right. So money well spent, in my humble opinion.
Yes,
right?
That's right.
The line and those documents in place to make sure your wishes are seen through, and that there's no real issues, when the day does come and you do have to, pass things on over to the next generation or your spouse or whatever happens. And
it's fairly inexpensive. Yeah,
absolutely. In the grand scheme of things, it's nothing, but very important to have. Doesn't compare to the amount of money that's going to be needed to spend if you die without those documents, in order to get things executed on your behalf.
Correct.
So there you go, Tim. Thank you very much. This was great. I don't know if there's any questions from the audience at all, Raheem or Jeff. I don't see it on my end, but
just a quick question. Just using the experience of Tim, broaching the conversation or starting it between spouses, between parents and kids, and reversing that. Parents, in lieu of the kind of environment we are in now, where younger people should start planning a lot earlier. How do parents ensure that their children are planning? What are some, outside of stories, which humbly raises the outcomes, what are some strategies that you have found that have worked that help create awareness and create a more positive feeling in something that for a lot of people can be very difficult to examine and look at?
It's a very difficult, this can be a very difficult conversation, right? To have. And Raheem, you're speaking about what can parents do, right? To with respect to their children planning or as a family unit planning?
Both.
Both. That's right. Now, I'll tell you, this is what I do for a living, right? And sometimes it is quite challenging because when you speak, it just goes over. You know, it's what I do for work. And I bring up the conversation at times at home. And certainly age appropriate, because like I said, you know, my kids are 20 and my daughter will soon be 18. What we did very recently, we've talked to them over time, but one of the things that we did, there is this show on TV, it's, I forget the channel, used to tell us, but it's called Zoomer Magazine, right? And we recorded an hour-long estate planning show that they did. And so I recorded the show after a couple of weeks, and we also have a niece that is single. And so all 5 of us, we sat down and we spent 2 hours. Because now it wasn't coming from me, it was coming from a third party. This is why the advisor is key. It's coming from a third party. And so we paused, we rewound, we fast forward, we did all of that. And we had an exhaustive conversation for 2 hours. We brought out our wills, showed it to our kids, they reviewed the wills, and we had, again, a good conversation around that. So family specific, family centric, you know, based on your particular circumstance, but we can look for ways to begin and start these sorts of conversation. A third party, in this case, the TV was the third party. But certainly it could be you, Rahim, that your clients, or you engage your clients and say, and I think Mark mentioned this, I am dispassionate. I am here for everyone's benefit and for everyone's good. And so can we have this conversation? And I think that would help and push this and advance this sort of conversation. Finally, I'll say this just by way of another story, and this was in the Yukon. I was speaking with a fairly elderly gentleman, and he had 2 daughters. He gathered them to have an estate planning conversation, himself, his wife, and his 2 kids. And as soon as he started, he didn't tell them what the conversation was going to be about. He just said, let's just gather. And they sat around the dining table, and he said, this is what I want to talk about. You know what happened? His 2 daughters got up and left, because dad was going to talk about his death. That's all they gathered from this potential conversation. You're going to talk about your death. I don't want to be part of that. I cannot imagine you not being here. But if you bring someone that can hold all hands and say, it's okay, it's an important conversation, let's have it, I think that goes a long way.
That's great. And I appreciate that, those words of wisdom. Jeff is actually from the Yukon originally, so that story will resonate nicely there. You know, in the interest of time, what I would suggest to our audience is to reach out to us. Myself, Jeffrey, Mark, and Tim are resources that are available for your needs. We have checklists and guidelines, but ultimately we're here to help position and move you in the right direction. So please lean on us in terms of how we can either structure conversations, structure planning for you. At the end of the day, your success is our success, and the ability for you to mitigate potential conflicts in the future helps us move you in the right direction in terms of planning. So that's enough for me. Mark, any closing thoughts, and then Jeff can round it out.
Yeah, no, I agree, Rahim. I think that's invaluable advice to depart with. You know, to lean on professionals such as yourself. I think that's imperative for individuals to do, and you guys have done such a fantastic job over the years, and not to be shy to have these type of conversations with people around you, your family members and others. It's imperative that we do it. Those stats of 50% of Canadians not having a will, or 75% of business owners, that's a scary number. So anyway, very much appreciate you having myself and Tim on here. Once again, very grateful for that. And with that, I'm going to hand things over to Jeff to wrap it up.
Perfect. Thanks again, everyone. And this meeting was recorded, so we're just going to pass it through compliance and get it out to you right away. If there's any questions or thoughts, like I said, and Raheem said earlier, please reach out to us. This is something that's very important to us, and it is a tough conversation for some people, but it's one that can make a big difference and a big impact on your life. And it's easy to get started, especially with us. It's a confidential conversation, and share with us, and we can help guide you and give you a couple of suggestions and start it from there. Sometimes it's just the baby steps. With that, feel free to reach out to us on email, our website, mywealthmanager.ca, or check our Facebook page at facebook.com/mywealthmanager.ca, and we'll have this posted there a little bit later on today. Have a great one.
Appreciate it. Thanks,
Thanks,
everyone.
Tim. Thanks, Mark.
Thanks, guys.